Parens Patriae. Why the court gets involved in your family's affairs. If you are involved in a divorce or child custody dispute, there is something important you need to understand early. Once children are involved, this is no longer just a dispute between two adults. The court claims an independent interest in protecting the child or children, and the doctrine behind that principle is called Parens Patriae. The phrase is Latin. It roughly means parent of the country. In practical terms, it means the state has both the authority and, in some situations, the obligation to step in and protect people who cannot fully protect themselves, especially children. This doctrine goes back centuries into English common law and carried forward into American law. Courts, including the United States Supreme Court, have long recognized that parents have fundamental rights, but those rights are not absolute when a child's welfare is at issue. This is why judges can override agreements both parents want in a child custody dispute. Many people assume that if both parents agree, the court must approve that agreement. That is not true. Courts often approve agreements, but they do not have to. If the judge believes the agreement is not in the child's best interest, the judge can reject it. Now, a judge can reject it on other grounds as well, but this is a Parens Patriae discussion. Parens Patriae in action is what I just described. It also changes the role of the court itself. In ordinary civil litigation, judges mostly resolve disputes based upon the record the parties present. In child custody disputes, the court can actively expand the record on its own. The court can appoint a guardian ad litem, order a custody evaluation, interview the children itself in camera, require therapy, or impose restrictions on parent time. The court is not simply refereeing a disagreement. It can actively shape the case. And that is where most people become frustrated. Parents understandably believe they should control decisions involving their own children. From the court's perspective, however, protecting the child is part of the court's institutional responsibility. Sometimes that discretion is exercised carefully and thoughtfully. Sometimes it is not. Courts often rely heavily upon guardians ad litem, therapists, and custody evaluators who filter information through their own interpretations. Sometimes they get it right, sometimes they do not, but their opinions can carry enormous influence. The practical takeaway is this. If you are involved in a child custody dispute, stop treating the case as merely a fight between you and the other parent. You are trying to persuade the court. Your credibility matters enormously. Judges watch how you behave, how you think, and whether you appear focused on the child's welfare or merely on defeating the other parent. Whether people like it or not, Parens Patriae is the reason the court is involved in your family at all. Understanding that helps people stop wasting energy fighting the wrong battle.